Okay, so let's unpack this. Imagine you've got a piece of property, right? And you're thinking about how to transfer it.
Mhm.
Maybe you've heard people talk, friends or family, about using something that sounds, well, simpler than a full-blown registered sale deed.
Yeah, you hear that sometimes.
Could you just use, say, a power of attorney, maybe combine it with a sale agreement?
Or maybe throw in an affidavit or even a will, thinking that somehow that package does the job,
Yeah.
transfers the actual ownership.
Exactly. It sounds convenient, doesn't it?
Yeah.
Maybe cheaper, less hassle, avoids all the legal stuff you think is complicated.
It sounds convenient, but here's the crucial question, the one we really need to dig into. Is that legally sound? Can you actually transfer legal ownership that way in India?
And that's such a common thought, isn't it? But it seems it comes from a pretty persistent misconception.
It really does.
Yeah.
And what looks like a simple workaround can actually cause huge legal problems later on. Massive headaches.
Right, and that's exactly what we're diving into today. This deep dive is all about cutting through that confusion. We're looking at why using these methods relying just on unregistered documents like a general power of attorney or a sale agreement, maybe a will, even if you intend them to transfer legal title,
Right.
why they just don't work under Indian law for immovable property.
Right. Our mission here is basically to pull out the most vital legal nuggets from the sources we've looked at. That includes the big one, the 2012 Suraj Lamp judgment from the Supreme Court,
Okay.
and importantly, insights from two very recent Supreme Court judgments, one from late 2023 and another from just this past February 2025.
So really current thinking from the court.
Absolutely. And the goal is to simplify the core legal reasoning behind all this and give you clear, practical takeaways. Think of it as your shortcut to being properly informed on this specific, really important point of property law.
Okay, let's zero in on that problem then, the allure of the shortcut. What exactly are people trying to do with these documents?
Well, fundamentally, they're trying to bypass the formal, legally required process. They use things like an unregistered general power of attorney,
Yeah.
giving someone else power to act on their behalf. Sometimes they pair it with an agreement to sell, which is technically just a contract to sell later.
Okay.
Maybe they add an affidavit saying possession has been handed over, or even a will bequeathing the property. And the intention behind this whole bundle of documents is that it somehow acts as the transfer itself.
Without actually going and getting a proper sale deed registered.
Exactly. Without executing and registering that crucial sale deed. Maybe they think they're saving on stamp duty or registration fees, or just avoiding what seems like a complicated trip to the sub-registrar's office.
So the intent is there, they want it to be a transfer, but the law. Well, the law sounds like it's very specific about how legal title actually changes hands for property.
Very, very specific. And that brings us right to the foundation, doesn't it? The absolute non-negotiable legal requirement. What is the only recognized way to transfer ownership of valuable immovable property?
Okay, lay it out for us.
For pretty much any immovable property valued at Rs 100 or more.
Which, let's be honest, is basically all property these days.
Right, essentially all of it. The transfer must be done through a properly executed, and this is the key part, registered deed of conveyance.
So a registered sale deed if it's a sale, a registered gift deed if it's a gift, that kind of thing.
Precisely. And it has to be registered with the authorities.
And this isn't some brand new rule the courts just invented.
Not at all. This comes straight from fundamental laws that have been on the books for, well, over a century.
Wow, okay. Which ones?
We're primarily talking about Section 17 of the Registration Act, 1908. This makes registration compulsory mandatory for documents that create, declare, assign, limit, or extinguish any right, title, or interest in immovable property over that 100 rupee value.
Got it. Section 17.
And also Section 54 of the Transfer of Property Act, 1882. That defines what a sale is and explicitly states that for tangible, immovable property worth 100 rupees or more, the sale can be made only by a registered instrument.
Only, that's a strong word.
It is. The law is unambiguous on this.
And this is basically what the Supreme Court hammered home in that famous Suraj Lamp case back in 2012, right? Suraj Lamp Industries versus State of Haryana.
Absolutely. Suraj Lamp was pivotal. It looked directly at this very practice, people trying to use GPAs, agreements to wills, this whole package deal instead of a registered deed.
And what did the court say?
Unequivocally, they said these methods do not convey title. They are not recognized as valid modes of transfer. Full stop. The court even called it a pernicious practice.
Pernicious practice, strong language.
Wary, because it bypasses legal requirements, creates uncertainty, potential for fraud. Suraj Lamp really drew a clear line in the sand. No more ambiguity.
Okay, so Suraj Lamp lays down the principle loud and clear in 2012. But you know how it is in law, people sometimes look for loopholes or argue about specifics. So let's look at how these two very recent Supreme Court judgments have dealt with this. How have they reinforced or maybe clarified things further? Let's start with the 2023 case, Shakil Ahmed versus Syed Akhlaq Hussain.
Right. This case, decided just last November, November 1st, 2023, is a really powerful reinforcement of that Suraj Lamp principle.
Okay.
The basic situation was pretty straightforward. One person, Syed Akhlaq Hussain, filed a lawsuit asking for possession of a property.
And what was his claim based on? What documents did he have?
That's the crucial part. His claim was based on a collection of unregistered documents, a power of attorney, an agreement to sell, an affidavit, and a will, all supposedly from the original owner.
All unregistered.
All unregistered. The other party, Shakil Ahmed, was the one actually in possession, and they had their own claim based on an oral gift, which the court rejected anyway. But the key issue was the legal basis for the plaintiff, Hussain, demanding possession.
So the core question for the Supreme Court was, can you actually use these unregistered documents, the GPA, the agreement, the will, as your proof of ownership to win a lawsuit for possession?
Exactly. Can these documents form the basis of a valid claim to title in court?
Then the court's answer.
A clear, definitive no. They stated very plainly that, and this is interesting, irrespective of what was decided in Suraj Lamp's.
Meaning this was the law even before Suraj Lamp spelled it out.
Precisely. They said no title can be transferred for immovable property based purely on an unregistered agreement to sell or an unregistered general power of attorney. They pointed straight back to Section 17 and 49 of the Registration Act and Section 54 of the Transfer of Property Act.
And Section 49 of the Registration Act, that essentially says an unregistered document that should have been registered doesn't affect the property. Right?
Exactly. It doesn't confer any legal right, title, or interest that you can enforce in court, especially not in a suit for possession based on title. The unregistered document just doesn't give you that standing.
What about the agreement to sell, though? Did the court say it was completely useless in that lawsuit?
Not completely useless, but useless for claiming title. The court clarified that an agreement to sell can be used for limited collateral purposes.
Like what?
Like maybe as evidence that there was an agreement between the parties. Or, importantly, it could be the basis for a different type of lawsuit called specific performance.
Ah, where you ask the court to force the seller to actually go through with the sale and execute a registered deed.
Exactly. But you cannot use that unregistered agreement to say, I already own this property. Give me possession based on my title. It doesn't establish title.
Got it. Now, there was another argument in this case, wasn't there? Something about whether the Suraj Lamp ruling only applied after 2012, like maybe transactions before that were okay.
Yes, that argument came up that Suraj Lamp should only apply prospectively, but the Supreme Court firmly rejected it.
And their reasoning?
Quite logical, really. They pointed out that the requirement for compulsory registration doesn't come from the Suraj Lamp judgment itself. Suraj Lamp merely approved and confirmed the legal position that was already mandated by the Registration Act and the Transfer of Property Act laws that have existed for over 100 years.
So Suraj Lamp didn't create the rule, it just highlighted and enforced the existing rule that people were maybe ignoring.
Precisely. The statutory requirement was always there.
Interesting. And the Supreme Court also corrected something the High Court did, something about how the lawsuit was filed.
Yes, that's an interesting procedural point. The High Court seems to have gotten a bit sidetracked. Because the plaintiff held a power of attorney from the original owner, the High Court thought maybe the suit was valid because he was suing as the owner's attorney.
Okay.
But the Supreme Court looked closely at the plaint, that's the formal document you filed to start a lawsuit, outlining your claim. And they saw that the plaintiff wasn't just suing on behalf of the original owner using the GPA. He was personally claiming he was the owner, based on that package of invalid unregistered documents.
Ah, so he was claiming ownership for himself, based on documents that couldn't give him ownership.
Exactly, and that distinction is crucial. How you frame your legal claim matters immensely. You can't base a claim of ownership on documents that the law explicitly says do not transfer ownership.
So the practical takeaway from this Shakil Ahmed case, the 2023 one, is really crystal clear then.
Absolutely. It's a powerful, very recent reaffirmation from the highest court. Those unregistered shortcut documents, GPA, SA, affidavit, are legally insufficient. They do not transfer title. You cannot rely on them as proof of ownership to claim property in court.
Oh.
It confirms Suraj Lamp wasn't some new invention, but a necessary clarification of long-standing law.
Okay, that really solidifies the basic principle, but let's go even deeper now with the second recent case, the one from February 2025, MS and Enthemurthy and NR versus J. Mangila. This one sounds like it tackles a more complex scenario, maybe an argument people try to use to make these GPA sales work even after the original owner has passed away.
That's exactly right. This 2025 case, decided February 27th, deals with a more layered set of facts and specifically addresses that agency coupled with interest argument you sometimes hear.
Okay, set the scene for us. What happened here?
So the original owner gave an unregistered GPA and an agreement to sell way back in 1986. He then passed away in 1997.
Owner dies. Now what?
Now, here's the twist. In 1998, after the original owner's death, the son of the person who held that old, unregistered GPA used it to execute a registered sale deed in his own favor.
Wait, using the GPA of a deceased person?
Exactly. That was their claim. But, meanwhile, the legal heirs of the original owner, the ones who inherited the property legally, they subsequently sold the same property. And they did it properly through registered deeds in 2003.
Okay, so we have competing claims originating from the same property.
Precisely. There was a chain of registered transfers from the legal heirs, eventually leading to the final owner on that side, J. Mangila, who was the respondent in the Supreme Court, who got it via a registered gift deed in 2004. So the fight was between the person claiming via the GPA sale done after the owner's death and the person claiming through the registered deeds from the owner's actual heirs.
So the argument from the side using the old GPA must have been something like, this GPA wasn't just any GPA, it didn't become invalid when the owner died? How did they try to argue that?
Exactly their point. Their key argument was that this GPA was irrevocable because it was coupled with interest.
Coupled with interest. What does that mean in this context?
They argued that because the GPA was given alongside an agreement to sell, and presumably some money had changed hands as consideration, the person holding the GPA had acquired an interest in the property itself.
Okay.
And under Section 202 of the Indian Contract Act, there's an exception to the general rule that agency terminates on death. If the agency is coupled with interest, they argued, it doesn't terminate when the principal, the original owner, dies. Therefore, the GPA holder, or his son in this case, could still validly execute the sale deed even after the owner's death.
That sounds like a clever legal argument, trying to use contract law to keep the power alive. How did the Supreme Court tackle this coupled with interest claim?
They dissected it very carefully, and this is where we get really crucial clarification. First, they went back to basics. A GPA creates an agent-principal relationship. Under Section 201 of the Contract Act, the general rule is, yes, agency terminates on the death of the principal.
Right.
Then they look closely at Section 202, the exception for agency coupled with interest.
And what did they determine interest actually means for Section 202 to apply? Does just wanting to complete the sale count?
This is critical. The court clarified, no, it doesn't. The interest required by Section 202 must be an interest in the subject matter of the agency itself in this case, an interest in the property. It can't just be an interest in the outcome of the agency, like earning a commission or expecting a future profit from the sale.
So just being authorized to sell and collect money isn't enough?
Not according to the court. They cited previous judgments establishing this merely being authorized to sell or having a prospect of gain does not create the kind of interest that makes an agency irrevocable under Section 202 after the principal's death.
Okay, so the court looked at the specific unregistered GPA and agreement to sell in this case. Did they find that it created this special kind of interest in the property?
They found that it did not. Even reading the unregistered GPA and the agreement to sell together, the documents themselves didn't explicitly grant the agent a legally recognized interest in the property itself that would satisfy Section 202.
So even if the GPA said irrevocable?
Simply using the word irrevocable doesn't magically make it so if the underlying legal conditions for irrevocability, like a genuine interest in the property being created in the agent, aren't met. The substance matters more than the label.
Okay, that seems to knock down the Section 202 argument pretty effectively. But you said there was another layer to the court's reasoning.
Yes. And this is perhaps the most powerful point, the real knockout punch, especially concerning registration. The court added another crucial layer.
Go on.
They said, look, even if, hypothetically, you could argue that combining the unregistered GPA and the agreement to sell somehow intended or tried to create an interest in the immovable property for the agent. Any document that actually creates or transfers such an interest in immovable property worth over Rs 100 must be registered under Section 17(1)(b) of the Registration Act. We keep coming back to that.
The registration requirement again?
Exactly. And Section 49 says if it's not registered, it's ineffective for affecting the property. The court explicitly cited an earlier case, Chanagouda, confirming that even a power of attorney that does confer a right to sell property, coupled with interest, would require registration if it purports to create that interest.
So the very documents they were relying on to create the supposed interest needed to be registered themselves, but they weren't.
Precisely. It's a catch-22 for that argument. The unregistered GPA and agreement to sell, whether you look at them separately or together, couldn't legally transfer ownership or create the necessary type of interest in the property required for Section 202 because they lacked registration.
Wow. So the agency terminated upon the owner's death, full stop.
Correct. The agency legally ended in 1997 when the owner died. Therefore, the sale deed executed by the GPA holder's son in 1998 after the owner's death was completely invalid because the agent simply had no authority left to act.
That completely demolishes that agency coupled with interest argument when it's based on unregistered documents for property.
It really does. It closes that potential loophole very firmly by tying it back to the fundamental requirement of registration.
The court also quickly mentioned something about the type of lawsuit, right? An injunction suit, but they decided title.
Yes, just a brief procedural point. They confirmed that sometimes, even if a lawsuit starts as something seemingly simpler, like asking for an injunction in order to stop someone doing something, if the real underlying dispute is actually about who owns the property, if title is directly and substantially an issue, as the legal phrase goes, the court can and should decide that title issue to properly resolve the conflict.
Shows the courts try to get to the heart of the matter.
Exactly. They won't let procedural labels prevent them from deciding the core issue when necessary.
Okay, so why is this Ananthamurthy case from early 2025 so important for someone listening? What's the key takeaway here?
Well, it goes beyond just repeating unregistered documents don't transfer title. It specifically tackles and dismantles a more sophisticated legal argument, the agency coupled with interest argument that people were using to try and validate GPA sales, especially after the owner's death.
Right.
It powerfully reinforces that the registration requirement is paramount. You cannot bypass it, even with clever arguments about contract law exceptions like Section 202, if the documents creating that supposed interest aren't registered themselves. It adds another strong layer of confirmation.
Okay, let's pull all these threads together then. We have Suraj Lamp back in 2012 laying down the fundamental rule, then Shakil Ahmed in 2023 reinforcing it, making clear it's based on long-standing laws and that you can't use these unregistered documents to claim title in court. And now Ananthamurthy in 2025 going even further, specifically shutting down the agency coupled with interest argument when based on unregistered property documents.
The message from the Supreme Court, consistently, over more than a decade now, and reinforced very recently, is just absolutely undeniable.
So what is the single absolute key takeaway for anyone involved in property deals in India? The bottom line.
Unregistered general power of attorney, unregistered agreement to sell, wills. Whether you use them alone or bundle them together, they do not legally transfer ownership or title of immovable property in India, period, full stop. There are no clever workarounds using these documents alone to achieve a legal transfer of title.
And what happens, practically speaking, if you've relied on these documents thinking you own the property?
Well, the harsh reality is you simply don't have legal title in the eyes of the law.
So you can't prove ownership if challenged.
Exactly. You cannot use these documents to successfully prove your ownership or enforce your rights against someone who holds a valid registered deed for that same property. You also won't be able to get the official government land records, the mutation records updated, based solely on these unregistered documents.
So no legal certainty, no real security.
None. You're left in a very vulnerable position legally.
And this really highlights why registration is so important, doesn't it? It's not just a formality.
Absolutely not just a formality. As the courts keep stressing, registration provides legal certainty. It provides public notice. Anyone can check the records and see who the legal owner is. It gives security of title. It helps prevent fraud. It's the state's way of keeping track. And fundamentally, it's the only legally recognized method to transfer title for valuable, immovable property. It makes your ownership robust, verifiable, and legally protected.
So boiling it all down, what's the practical, actionable advice for our listeners based on these clear, repeated rulings from the Supreme Court?
If you are buying property or receiving it as a gift or acquiring it in any way, always insist on a properly executed and crucially registered deed. A registered sale deed, a registered gift deed, whatever fits the transaction. That is the only way to ensure you acquire clear legal title and your ownership is secure under the law.
And looking at it from the other side, what if someone is offering you property using only these other documents?
Be extremely cautious. In fact, the best advice is probably just to avoid any transaction where the seller or transferor is suggesting that ownership can be transferred using only unregistered documents like a GPA, an agreement to sell, or a will without following through with a registered deed.
Because these cases show.
As these Supreme Court cases clearly demonstrate time and time again, those methods are legally insufficient. They will not protect your claim to ownership if it's ever challenged. You simply will not have acquired legal title that way.
So we've really taken a deep dive into this core legal principle for property transfer in India. It's backed up by over a decade of clarity from the Supreme Court, including these two really strong recent judgments. They give us absolutely clear answers and shut down those common but flawed workarounds.
The message is consistent and unambiguous.
You know, the law's insistence on formal registration might seem like a hassle, maybe an extra cost up front.
It might feel that way sometimes.
But as these cases vividly illustrate, trying to bypass it with these unregistered shortcut documents, that creates immense legal uncertainty. What looks like saving a bit of time or money today
Can lead to far more complex, incredibly lengthy, and very expensive legal battles down the road, trying to prove an ownership that legally you just don't possess.
So, understanding this fundamental rule isn't just about legal compliance, is it?
No, it's absolutely essential for protecting your investment, your property, and ensuring you have genuine confidence and security in your ownership of immovable property in India. It's foundational.